Hi, welcome to Heald Law Academy. Today I wanted to tell you about a development in the area of 0 hours contracts. A 0 hours contract is a contract that doesn't promise a particular quantity of work. The employer may have a need for occasional workers and it's useful to be able to draw on that resource. However, the contracts have got quite a lot of negative publicity because they seem to be somewhat unfair to the employee who isn't really employed. They don't know how much work they're going to get from one week to the next. In May 2015, the government made it illegal to put a clause in a 0 hours contract that prevented an employee from working for somebody else. One can see the obvious injustice of having the employee agree to a contract and then saying that they couldn't work for somebody else. So that was seen as a very, very good development. In January of this year, the government's actually tightened the law even further. There were indications that in some cases employers were applying sanctions to employees who'd gone off and worked for somebody else, in other words, breaching the exclusivity which had been outlawed in May. If an employer does this, they will find themselves in the employment tribunal. It's automatically unfair to do this. There's no need for the employee to have gained the right that they normally only acquire after 2 years. It's automatically unfair and the employer is going to lose. So the message then for employers is clear. If you do need to use 0 hours contracts, firstly, you can't make it a condition that the employee cannot work for somebody else. And secondly, if you do, you're going to find yourself in hot water very quickly. If you need a more detailed explanation, please go to our website. Thank you.